And welcome back to the Law and Crime Network, and welcome to our Sirius XM listeners. We are covering a trial out of Michigan, the trial of Jeffrey Willis, who is being accused of killing and abducting Jessica Haringo, who was a 25-year-old mom who went missing in 2013 from her gas station attendant job. You were just listening to Susan Follett, who worked at the Exxon. She was a manager who happened to just be driving her motorcycle by the gas station that night, and she spotted a silver van behind the gas station and saw somebody who may have been Jeffrey Willis. But Julie Rendelman, Law and Crime trial analyst, she wasn't able to identify him at trial. How significant is that?
Well, it is significant. However, remember, almost all of this case is a circumstantial case. And so what they're going to try to do is, as they've been doing, is tie little pieces of what she's saying to other pieces to connect it to the defendant, meaning she noticed streaks in his hair. We have a witness who testifies that he was getting streaks in his hair at that time. We have the original kidnapped victim who describes the vehicle as being the same or similar to the vehicle that had driven up to the gas station. So all these things, obviously they would ideally want her to be able to ID, but they're able to put the pieces together around that.
Right, and just to put into context for our listeners on Sirius XM, he's also accused of abducting a teenager who escaped and is expected to testify at this trial. He was convicted already of the shooting death of Rebecca Bletch. This came after Jessica Haringo went missing. Mark Eiglarsh, a criminal defense attorney in Florida, is joining us. Mark, are you there?
I am, yes.
The judge agreed to allow evidence in from these other crimes, the one he was convicted of and the one that he's accused of, that he hasn't gone to trial yet. I understand the one where he's already been convicted. Let's bring that evidence in because the judge said that it supports a pattern, possibly, a scheme. But what about the one that he still has to stand trial for? Why would that alleged kidnapping victim be allowed to testify in this trial?
They're going to argue that it's intertwined. It's so together that you can't leave it out. It'll make jurors be confused as to what happened next. How did we get to the guy? You know, prosecutors have to prove that he was placed under lawful arrest. How did that occur? And when you tell the story, it begins and it's tied in to what happened with this teenage victim.
Right, and obviously her testimony is going to be so compelling that couldn't it potentially be prejudicial since he hasn't been convicted in that crime?
So, yeah, you know, just to add to what Mark's saying is that, remember, there is a gun recovered, and I believe that the victim, the surviving victim will say that, or has said, that the gun is the same as the gun that was recovered. So all these pieces tie together that allow the court to allow that specific witness in. I have to say, though, that in terms of the other killing, I think that there may be an appellate issue. I think there's always an appellate issue, obviously, with any of these cases. But if he is found guilty, I think that the defense will have a stronger argument in regards to prejudice, in regards to the killing of the other victim.
The one that he's been convicted of already? Why
correct.
Do you say that?
Well, because I'm not sure. I don't see the modus operandi as clearly as I see the relevance of the live victim. Remember, the individual who was killed, I believe she was jogging and came into the vehicle and was killed. I'm not sure that I'm seeing the pattern that one is supposed to establish. Now, the one thing I will say is that I believe there's evidence that he kept in some type of computer or some type of thing in his home his victim files, and it included all of these victims. So that may be the way to tie them in. But I do get concerned about some of the prejudicial aspects of that first deceased victim coming in.
Well, like you said, her name was on his computer file under the subheading VIX, right? And then you also have the common thread of this silver van,
sure.
where when they apprehended him and they searched it after the kidnapping victim came forward, they found all sorts of materials that they can use to connect him to all of these crimes. And, of course, they succeeded in the conviction. Mark, do you agree with Julie?
Yes, I do. I'm glad you called on me for this because while there are some similarities, the question is it so significant that you're going to allow that on one side? Again, everything is balanced. So you look at the other side. The prejudice is, wait a second, he did this before? He killed another woman before? Okay. We're not really going to be too concerned about anything after that. So there's that on the other side
Well,
of the scale.
actually, Mark, I just want to correct you because the Rebecca Blake killing came after. So do we have a timing problem here then? If this came before,
I don't
You
care
just
what.
go for it,
Ringa
Mark.
killing.
No, I don't think I don't think whether it came before or after is relevant when it comes to whether or not it's prejudicial or not.
Right.
Mark?
Yeah, there's the answer. I hear, I don't care if he killed a woman 10 years ago.
Right.
The burden of proof just got a lot lower for most jurors.
And
That's
remember, the judge didn't allow in other things. He didn't allow in certain things on his, I believe it's on his computer, when you know, some types of very like sexual deviant things and things about necrophilia that one might argue might even be more relevant than the death of the other young woman at his hands.
I'm glad you brought that up because I wanted to ask you about that. Why would he allow in these victim files? Obviously, they've got the names, so they're relevant, right? But not videos of torture and necrophilia and abduction of women. The prosecutors obviously are trying to prove, because he even had, you know, files and articles about serial killers, that maybe he was an aspiring serial killer. And he had this folder that said VIX, you know, it's almost as if he was building or compiling victims to meet that quota of being a serial killer. So why wouldn't they allow those videos in showing his propensity towards this type of graphic material and connect it with the way the crimes were carried out?
Mark, I'm like, Mark, do you want to take that? Go for it.
Set it up for one of us, whoever wants to take it.
Here, I'll lob it to you, Mark.
You go, Mark.
Did you catch it?
Yeah, listen, well, I'll take half and let Julie take it home. Listen, trials have to be fair, okay? I mean, we start with, why don't you just let in everyone who ever left the toilet seat up for, you know, and got pissed off at him? You know, obviously that's a little too far out, but you start bringing it in. Courts have to be very concerned about what they let in. If it's way too prejudicial and, you know, brings in other bad act evidence, bad character evidence, that's not fair, right? You can't just let everything in. Now, Julie, be more specific than me.
Oh, God. Well, remember, a lot of stuff is coming in this case, and that's why we talked about maybe too much is coming in. And you know, one of the issues is, remember how the gun is recovered in the first place. The reason the gun is recovered is because, the basis of we knowing kind of where this comes from is the gun had been stolen by from one of the defendant's co-workers, and he also had stolen like an item of her clothing. I believe it was
her underwear. Yeah.
And so that's coming in against him also. And so we start to talk about that coming in. Now we're talking about the other victim who survived. Now we're talking about the other victim who died at his hands. And so when a judge is weighing prejudicial first probative, yes, he has to weigh how much the jury's going to be impacted by what this additional evidence has to say. And my concern is in a circumstantial case, when you start bringing in too much outside, some of which is incredibly prejudicial, and I'm not sure so probative, I'm always worried that there's going to be an appeal issue. And that's why I'm just focused on that specific the victim who died, because that's the one that I think is the most prejudicial and the one that's the most concerning in terms of lack of relevancy to this case.
And as you mentioned, Julie, they did locate the gun that had been missing, and they say that that's what connects him to all of these crimes. Let's listen to some testimony from that coworker who says that he broke into her house, allegedly stole her gun and her underwear.
Convicted serial killer Jeffrey Willis took the stand in the kidnapping and murder trial of Jessica Horinga. Michelle Shanatola's gun and underwear were found when authorities searched Willis's van and home. Shanatola, who worked with Willis at Herman Miller's, claimed he knew where she lived and would often go snowmobiling near her residence. Willis knew she had a gun, and that very same gun went missing in February 2013 before it was later discovered in his van.
Now, can you tell us the last time that you saw that fire?
Was the weekend of February 22nd and 23rd of 2013.
I want to draw your attention to early March of 2013. Do you recall a time where you observed some snowmobile tracks around your house?
Yes.
Now, was that unusual or a normal occurrence? The snowmobile tracks, that is.
I call it unusual because it only happened one time a year.
This witness recalled the night when Willis came into work following Jessica Haringa's disappearance.
I recall him having scratch marks on his arms.
Did you ask him about those scratch marks?
Yes.
And what did the defendant tell you about them?
He told me that he had a new puppy, a playful puppy.
And was it the puppy that caused the scratch marks?
Yes.
Authorities discovered 2 pairs of her underwear in Willis's shed. She testified there was no reason for them to be there, and she claimed Willis had a weird fascination with her undergarments.
He'd always say, "Can I have a pair of your underwear?" And I would, no.
Okay.
On cross-examination, the defense pressed her about her memory of when Jessica Haringa went missing.
The point that's being made here is the day after Ms. Haringa disappears, you notice those scratches. But you've testified you don't remember the date Ms. Haringa disappeared. And so the question is, how do you know it was the day after?
I don't.
Okay.
Willis is currently serving a life sentence for another woman's murder and is awaiting trial for the abduction of a teenage girl. For Law and Crime, I'm Rachel Stockman.
And so you were just listening to some of that testimony from a coworker of Jeffrey Willis, who says that she noticed scratch marks on his arm, but she wasn't able to zero in on whether she saw them the day after Jessica Haringa went missing. Mark, his excuse to her over the scratch marks was that he bought a new puppy. You let out, I'm not sure, was that a belch or a laugh? You let out some sort of a noise.
A loud chuckle.
Yeah, so what's so funny about that? That just the excuse that it was a puppy? Meanwhile, it may have been a murder victim?
No. Clearly, how the pattern in this case, because I listened to his testimony in the first trial, he has an excuse for everything. And what's interesting is he's not a dumb guy. So he's able to make the next best explanation other than, because I'm guilty because some woman was scratching me trying to save her own life. But the next best thing is, well, a puppy did it because puppies do scratch. I had a puppy. The dog scratches. That makes sense. And she can't date it. But I'm laughing because I know he's guilty as can be, maybe, allegedly. And it just seems silly. It seems very he's trying to save himself.
And that's coming from a criminal defense attorney. You're supposed to take the other side, right?
No, I'm not one of those. I'm a human being, and I call it like I see it.
Great. Now, Julie, what about this fact that she's saying her underwear went missing, but he used to ask her for her underwear? Supposedly on a regular basis, he made requests to get her underwear. I mean, just bizarre, right? But the fact that they found it in his possession, why does that relate to this whole case? What does it show to the jury?
I'm not sure that I'm not sure it is relevant.
So would you have objected to that? Because it sort of shows a bizarre element of his personality.
Let's be clear that the defense is objecting to all this stuff coming in. I don't think they want any of it coming in. I think the issue is that that the judge is allowing it in, and so now they have to deal with conquering the credibility of each of these witnesses as they testify. And for her, I think it's damaging for the jury to hear that he was obsessed with a woman's underwear. That's separate and apart from this victim. The reason she's relevant, as far as I'm concerned, is because she's the one he got the gun from. And so that's the relevant part that she has to give this jury. The underwear is kind of like an added bonus for the prosecution, as far as I'm concerned.
A bonus? Is that what we're calling it?
A bonus, yes. A bonus. Well, if you're the prosecution, you want it in. So why not? The judge rules in your favor, so great.
So why do you want it in, Mark? Just to show that this guy was a bizarro?
But the exact reason why I want it out. If I'm a prosecutor, I want it in because I want these jurors to clearly see that he's as different as the average juror as possible, and worse, that he's actually creepy, because only someone really creepy commits this kind of murder.
And I will add something. Maybe it's like what a prosecutor's not supposed to do, but keep in mind, as a prosecutor, you don't want an appeal. And so sometimes taking too much cannot be the best thing for you. And so even as a prosecutor, even if the judge is giving you things, sometimes you can actually resist taking it and say, you know what, you as a prosecutor yourself can balance what you want the judge to bring in and what you don't, just because you don't want an appeal later either. And if you think the evidence that's coming in shouldn't be coming in, then you have to be cognizant of that as well.
And let me tell you something, Amy, you have with you in studio someone who I know could have gotten evidence that she wanted in certain of her homicide cases, but she didn't even ask the judge because she doesn't want to try that case twice. I know you, Julie.
Julie Rendelman. So let me ask you, though, Julie, then what would you have done in this case? Would you have resisted the introduction of the underwear evidence?
I mean, it's a great question.
Do you think that's an appealable issue?
The laws there may be very different than they are in New York, okay? So, you know, anytime you're making a decision about what comes in and what doesn't come in, you have to decide based on what your the case law is in your state. But if in New York, I think the case law is a little more liberal, and so they're going to be a little more siding for the defendant. And so I would tend to think many judges would not have allowed in a lot of this extrinsic evidence.
But Mark, does it bolster the claim? Does it help establish that he broke into the house, Mark? Because here's the thing. The gun was missing, so was the underwear. So does the fact that the underwear went missing, it helps establish that he was there because they found him with the underwear, so therefore he took the gun?
Yeah, no, you're great at arguing why the stuff should come in, but we like to focus on what good is a conviction if there's a likelihood that it's going to get taken away and the victims are going to have to go through all this again, the next of kin. So we're trying to do a clean trial here, right? And I got to respond to, I was still laughing at what Julie was saying. Listen, I forget what state this is in.
Michigan.
Yes. There's no creepy guy panty exception in the evidence code, okay?
I've heard of it. I've heard of the creepy guy exception. Creepy guy exception.
With it.
Only in Michigan.
Okay, guys, so
yeah.
You know what? There's something a little bit odd and almost heartbreaking about this case. The mother of Jessica Horinga is still holding out hope. She actually posted something that indicates she thinks her daughter is still alive. Remember, the body has never been found. We're going to take a quick break, and we will come back and listen to some testimony from relatives, and we will see that post from the mother. So please stay with us. And welcome back to the Law and Crime Network, and welcome to our Sirius XM listeners. We are covering a trial out of Michigan. This is Jeffrey Willis, who is accused of killing and abducting Jessica Horinga, who went missing, though her body has never been found. Jeffrey Willis was already convicted in the shooting death of Rebecca Blech, and he is accused of kidnapping a teenager who escaped. And a lot of the evidence from the accusation and the conviction are going to be presented in this trial. Some of it already has been. I'm here with Julie Rendelman, who's a law and crime trial analyst, and Mark Eiglarsh. Julie, we were talking about the introduction of some of this evidence in our last block and some of the stuff that's been excluded. And we were just, to give our viewers a little recap, talking about the fact that one of the coworkers of Jeffrey Willis said that her underwear went missing. And that has come into trial. And you, Mark, were sort of arguing over, whether that would be prejudicial or not. Some of the other evidence I just want to touch upon again, really briefly, is there were some videos, graphic videos on the computer. And both you and Mark didn't feel that that should come in. But listen, let's go back to that, because here it's very important. They're trying to establish that he was an aspiring serial killer, that there was a pattern and a scheme, and that's why all of the evidence from the conviction is coming in, almost all of it, and this other kidnapping. So wouldn't you show those videos of that he was attracted to torturing, raping women, necrophilia, all of this graphic stuff, to show that, listen, this guy, he has a problem, okay? He likes odd stuff. Because if you're talking about introducing underwear, which you both felt was prejudicial, why would the underwear be admitted to show that he's sort of got an eccentric, bizarre behavior of taking women's underwear, but not the stuff that could relate to the actual killings that took place?
I mean, I can't speak for what the judge's thought process was in determining what comes in and what doesn't. I think you made a very good point when you said that, part of the issue is how do you prove the burglary or the stealing of those items so that you can prove that the gun came from her and we know it's the gun that's related
from the
to
coworker.
This case. Right. And so maybe there is an argument to be made is the fact that the underwear was stolen also further established that he is the person that stole it from her. In terms of the other things, I don't think, just like there's no exception to the creepy man rule in Michigan, I don't think there's the I want to be a future serial killer rule that comes in, that allows in any evidence you want that establishes you kind of want to be a serial killer. You must understand that this case is a circumstantial case where the body wasn't found. That doesn't mean that the prosecutor gets to say whatever they want to prove that he is the guy that did it. And you have to be really careful that every piece of evidence that comes in is relevant and has probative and prejudice weighed against each other to make a determination as to whether it should come in.
But Mark, what about all the tools and materials that were found in the silver van that he owned that was searched? I mean, you had syringes, you know, ropes, just different things that were used. Why handcuffs we can see there, a belt, batteries, a gun. So why wouldn't you show those videos to say, listen, this guy watched torture videos, and these were the materials he used to commit the torture?
Okay, Julie did a great job, but there's a couple of more words that I can use that hopefully will help everybody here. Okay, the answer is yes, it's relevant, right? It's not like, well, he did something creepy to a dog when he was 7. Okay, it's relevant. So there's a certain amount of relevance it has. But now we look at the prejudicial effect, right? Why it shouldn't come in, why it's prejudicial, okay? And what Julie correctly stated was, this is a circumstantial evidence case. And what she means by that is, to some extent, we don't have a busload of nuns who saw him do it. We don't have a confession. We don't have DNA. We don't have other evidence that if the appellate court found that the introduction of the things that you're discussing right now, these videos or whatever else, that somehow if the court finds that introducing those videos, let's say, is a problem, they can't say, well, it's harmless because there's so much other evidence that we've got that the jury would have reached the same verdict. It's a circumstantial evidence case, piece by piece. It's not as strong as some other cases. So admitting something like you're saying, a video like this, could be the difference between having to try this case again or not.
But what about the fact, Julie, that the cousin of the accused, Jeffrey Willis's cousin, Blum, who admitted to police, later recounting, but admitted to police that he helped dispose of the body, later pled to that. He pled no contest. He said to police initially that he saw Jessica Horinga's naked body tied up, right, and he saw a video camera nearby. So wouldn't the prosecution push to say, listen, not only did he torture these women, not only did he use all the materials that we found in the van, but he videotaped it. And he did so because he was trying to mimic the stuff that he saw in these videos that we found on his computer.
I don't disagree with you, and I have to say I think that the videos are more relevant than the death of the other young woman. I think that they, you know, and look, the judge didn't have to bring in every single video. He could have picked 1 or 2 to allow the jury to see. But that, to me, would have been more probative of guilt, coupled with potentially what the witness will say in regards to him videotaping, much more so than the death of the other young woman.
So, Mark, is the problem here, like you said, that there's no body with marks on it, so there's no indication of torture, meaning if you had a body and it had bruises on it or it had indications that these tools were used on it to torture the body, then would those videos on the computer be relevant?
Certainly more relevant. Everything is fact sensitive. You know, everything hinges upon what facts are available. So, yes, there would be a stronger argument for that, yes.
Okay, so Jessica Horinga had a 3-year-old son. Her boyfriend testified earlier in the trial. Let's listen to a clip of that. Welcome back to the Law and Crime Network. Welcome to our Sirius XM listeners. You were just listening to testimony from Dakota Quayle Dyer. He's the boyfriend and also the father of the son of Jessica Horinga, who went missing. Her body's never been found, but we have Jeffrey Willis out of Michigan, who is on trial for her killing. It was brought up in this testimony, Mark Eiglarsh, your criminal defense attorney in Florida, I should introduce you. It was brought up that Jessica Horinga had a problem with drugs, that she was a heroin user. Is that prejudicial?
I don't know. How do you feel about it? I mean, it's something I'd want to keep out, but I don't look, anybody could be murdered. I don't know how relevant that is.
Yeah, so why was that brought in, Julie? Because it seems like it's a little bit defamatory to her. I mean, you have her boyfriend saying that she was a heroin user, but isn't that hearsay in a sense?
I don't know. And, you know, remember, unfortunately, when it comes, or fortunately for a defendant, when it comes to prejudicial versus probative, we're usually, at least in most situations, more focused on the defendant's rights versus the deceased's rights, in a sense. And so, you know, the argument is that the reason it's coming in is potentially, if they can go down this road, is to potentially argue that there might be someone else who may have been more inclined to have killed her. Also, remember, she's missing, she hasn't been found. So, you know, obviously the prosecutor is assuming she's died. There might be an argument to be made that she is somewhere smoking, using drugs, still alive somewhere, or that she died of an overdose.
And Mark, you saw that they also went into a line of questioning that explored the nature of her relationships with her child, with her mother. Would she want to leave the child? And the boyfriend said no. Her relationship with the child was a 10. She would never leave her son. She never regretted being a parent, had a great relationship with all of her relatives. So is that what you think is trying to be established here, that maybe she's off somewhere using drugs and that she's still alive?
Well, that's one of the possibilities. There's only a few. If she wasn't killed, there's only a couple of other options. And one of them is she went off on her own, and they're trying to say she would never leave her kid. But what Julie said is pretty damn good. If somebody's using drugs, again, they're not in the right frame of mind, and maybe the defense could argue that she's off just, you know, obviously when you're doing drugs, certainly like heroin, you love that drug more than you do family members. So that's the argument. You add that to what we just heard earlier from another witness, the woman who was at the gas station and claims that the person did not have any facial hair, right?
The gas station manager who drove past the gas station saw a silver van, but wasn't able to identify Jeffrey Willis as the man in it.
Right, but she said then, not today, that person didn't have facial hair. Now, we know he did have facial hair. So now what? Now the defense is kind of talking about some, I don't know, some other person, no facial hair. Maybe he's got a big bag of heroin. You know, you're going to start to hear this kind of defense, and it has nothing to do with this defendant, they're going to argue.
And so what they're doing is they're trying to raise enough reasonable doubt for the jury to acquit. In a strange twist, again, we have a murder case here, but no body, and the victim's mother actually thinks her daughter's still alive. We'll talk about that more when we come back, so stay tuned. Welcome back to the Law and Crime Network, and welcome to our Sirius XM listeners. I'm here with Law and Crime trial analyst Julie Rendelman and criminal defense attorney Mark Eiglarsh. We were just talking before the break about the fact that we have a murder case here without a body. Jeffrey Willis is on trial out of Michigan for allegedly killing Jessica Haringa, who went missing but was never found. He's been convicted in the killing of Rebecca Blach, and he is also being accused in the kidnapping of another victim. And so the prosecutors are trying to show that possibly he's an aspiring serial killer, and this was all part of a pattern and plan. His van was found and searched, and there were a variety of things in there, including a gun, syringes, a rope, batteries, a whole grouping of tools here. But as I mentioned before, the mother of the victim, Jessica Haringa, or the alleged victim, thinks that possibly her daughter's still alive. Let's look at a graphic that she posted on social media. It says, "Today marks 5 years since my daughter was abducted. Please share, and share again to any site you belong to, your friends, anyone you can. Please share if you live in the United States or in another country. I will never quit looking for my daughter. The police have. Let's make this the year Jess comes home. She is alive. She is out there somewhere. Someone knows. Be my daughter's hero. No Jess, no justice." What do you make of this, Mark? Does this mean that Jessica Haringa's mother does not want Jeffrey Willis convicted in the murder, because then it's her accepting that her daughter's dead when we see she's still holding out hope that she's alive?
Yes, this woman, let me just say, I don't represent this guy. I have nothing to do with him. But if I did, this would create a pool of saliva underneath me, because she just became my star witness. They don't have a murder case without the jurors being convinced beyond a reasonable doubt that someone's dead. I call her as my star witness, and I make sure she knows that I believe in her, and that I credit everything that she says, and she knows more than anyone, especially the government or the state, whether her precious daughter is alive or not. So tell us why you believe that she is alive. And I pull that testimony out, and she starts to convince them as to why. And there you go. There's reasonable doubt.
But, Julie, couldn't it also be spun that this is a heartbreaking psychological crutch? And will the jurors see through that and think to themselves, well, maybe the daughter is dead, and the mom just does not want to accept it because it's too emotionally difficult.
Remember, if you look at the I think it's a tweet. I'm not sure. It looks like it's April 26th. So I'm not sure when this trial started. If I was the prosecutor,
I believe it's a Facebook post.
Or Facebook post. If I was the prosecutor, I would just be completely destroyed when I saw that post. But I agree with you to a degree. The problem is that what is she going to say? She could be a great witness if she says, my daughter was suicidal. My daughter loved to leave her child all the time, and she disappeared for days on end. You know, but if her testimony is going to be, I believe she's alive just because I feel it, then the jury's not going to buy that, and it's not going to be relevant to anything. You know, but of course the defense is enjoying, or at least wants that to be out there, as to how the jury's going to even find out about it unless she testifies. You know, that I don't know.
Amy,
yes.
I gotta go old school for a moment.
Go ahead, Mark.
There was a movie that I loved. I think it was Oh God. I don't know if it was Oh God 1 or 2 with George Burns.
This is really aging you, but go ahead, yeah.
Yeah, but some of your
viewers relate. Time, and I don't know how long, just so we get kind of a reference.
Are you there, Mark?
I can't hear.
I'm there. Yeah, they were playing some clip. Okay, so listen.
Okay, yeah. So I'm going to give you free license here to talk about old school movies, but I hope you'll relate it back to this case, Mark.
100%. I'm not here to give a movie review or anything. Okay, so in that movie, again, I'm not sure I have the facts right, but this is my understanding. At what point they call a witness, and everybody's head, I don't know if they called it, it was George Burns as God or just some witness that was supposed to have died. But the point is, in this case, for example, relating it to that movie, they would say, and the defense calls Jessica to the stand. And all of a sudden the door would open, because their assistant would open up the door, and jurors would look, right? And granted, it's a tactic. I don't know that Julie would ever do it. She's already making a face. Crazy, I know. The guy's already got a life sentence. So you know what? Desperate times call for desperate measures. I would do, if I'm ever going to do it, it's in a trial like this, and I say, folks, if you looked towards the door, that's reasonable doubt.
That's a good one. I like it.
You know what?
That's a good one.
Let me ask you something, though. What about the mere fact that there is no body and there are no witnesses?
Yes.
Okay, so you have the gun possibly connecting to the body, but there's no no gunshot.
But wait a second,
marks to connect it.
You do have more than that. You have blood, blood drops from outside of the gas station that are linked to her. You have a piece of the gun that is recovered from the scene. Remember, the gun that was recovered was missing a piece, and that piece was recovered from the scene from the gas station, and so that links to him. And then you attach the gun as being the one stolen from the girl who worked for him, and so slowly we are moving in towards A, her being dead, and B, him being the culprit.
And you have the files with the name Vince, and her name is on it. Her name is on the file.
And hold on, and you got a teenage girl who's saying, that guy over there tried to take me away in his van, the van that someone saw outside the gas station.
Okay, so you know what, Mark? That's a great point. Let's listen to some of the testimony from the alleged kidnapped victim who says Jeffrey Willis abducted her and she escaped. And that's some earlier testimony from Madison Nygaard, the alleged kidnapping victim of Jeffrey Willis, Julie Rendelman. There will be a trial coming up, but she's been allowed to testify in this Jessica Horinga case. How damaging is it, and the fact that she identified him?
I think, it's incredibly damaging and I think relevant, because it puts the car into play, because we know that the car is similar to the car. It puts the gun into play as well. And so I think, unfortunately for the defense, this is something that's coming in.
Okay, perfect. So we got up to the moment where she went with him, tried to use his phone. He indicated to her the phone doesn't work. She's about to realize that she's not getting out of that situation so easily. We will have more of her riveting testimony coming up. So please stay tuned. And also our Sirius XM listeners, stay with us for more of that testimony in the Jeffrey Willis trial on Law and Crime Network.